My name is Tlo Pitlela from the Legal Aid South Africa in conjunction with the Department of Justice and Constitutional Development. I'm going to be speaking to you about a will. What is a will? Who is competent to make a will? What are the formalities for a will? When must you amend your will? And also where you can store your will. Now, a will is a testament or a document in which you nominate a person who is going to be a beneficiary. That is the person who is going to inherit your estate when you die. What is an estate? It's your assets and liabilities. Anything that you own forms part of your estate. Now, who is competent to make a will? Anybody who is of the age of 16 years and who is able to appreciate the implications of making a will. That is a person who has the mental capacity to understand what is the importance and what the act of making a will involves. The formalities of a will are that it must be in writing. It can be handwritten, it can be typed, but it must be in writing, and it must be witnessed by two competent witnesses or more. A competent witness would be somebody who is above the age of 14 years and who is able to give evidence before a court of law in the event that there are questions around the capacity of the testator. So it must be in writing, it must be witnessed. The witnesses must sign on, they must initial each and every page, and they must sign the last page of the will. If it's a one-page will, then they will just sign the one-page will. Now, the testator as well must sign in the presence of those witnesses. Or if a person cannot write, then you are allowed to sign by way of a mark. A mark would be where you make a cross or you put your thumbprint. But if you are going to sign by doing that or putting a thumbprint, then there must be a commissioner of oath who is going to certify that indeed he is satisfied of your identity, that you are the testator and that this is your will. So those are the formalities for making a will. Now, what happens if you get divorced? When you get divorced, the law provides that you've got a period of 3 months within which to amend your will. That is to say that if you die within that 3 months period and your spouse was nominated in your will, then your spouse is not going to benefit. There's a revocation, a general revocation, which says that your spouse will not inherit anything, unless you have specifically indicated that you want your spouse to inherit in those circumstances. But once a period of 3 months has elapsed, and if you haven't made any changes to your will, then it follows that the spouse is going to inherit without any disqualification. So it is important for you, whenever there is an important event in your life, that is maybe the birth of a child or you're getting divorced, you need to revisit your will and you need to amend it. It is important. How you amend a will, you can use a codicil. A codicil would be wherein you make an addition to the will. And also, if you do that process of a codicil, which must also be in writing, it must also comply with the formalities. So it must be in writing and it must be witnessed by 2 competent or more people. So in which you can then amend your will. Or you can simply create another will. What is important is that in that will, the second will, you need to have a revocation clause where you're saying, I'm revoking all the previous wills that I've ever created. So that is how you then amend the will. Needless to say, only a living person or the testator, him or herself. A testator is then a male person and a female person is a testatrix. Yes, so that is how you'd amend the will. Now, once you have created a will, the question would be, where do you keep a will? It is not necessary for you to have a lawyer in order for you to make a will in the sense of him keeping the document for you. You can keep the document in a safe place, wherein the only important thing is to have somebody you trust, whom you're going to inform where to find the document in the event of your death. So you can keep the will at home safely, and in the event that you should die, then the person will then be able to present that will to the office of the master. So during these times, it is unpleasant to speak of death. However, it is important that as you are able to leave a will, which will then give the surviving members of your family an indication of what were your last wishes. And this will also avoid arguments regarding who must get what or where you must be buried and those type of things. So it's very important that you should have a will. It's a process that we offer for free at Legal Aid. So come to any of our offices. We have 128 offices nationwide, so you can visit either one of them at any time of the year, January to December. We are able to assist you to make a will. If you need advice, also you can phone our call center. It's 0800 110 110. That is 0800 110 110. Or you can visit our website and we'll be able to assist you and offer you or refer you to the nearest office. Thank you.